Welcome to WG University Weber Gallagher series of educational programs. This is our employment webinar series. I'm Jennifer Laver, and I'm presenting today with John Kuttner from our Mount Laurel office. If you would like to view this webinar again, share it with others, or see our other WG University programs, please visit Weber Gallagher's website at www.wglaw.com. There you will find copies of this presentation and others under the WG University page. Also, feel free to contact the firm with any questions at questions@wglaw.com. I know with regard to this topic, there are some of the PowerPoint presentations that you want copies of, so you can also email at questions@wglaw.com with regard to asking for a copy of the PowerPoint presentation. Today's presentation is workers' comp, ADA, medical marijuana. So let's get started. John's going to talk about medical marijuana first.
Thanks, Jen. Welcome everybody that's watching. So we're going to talk about marijuana and the legalization of marijuana recreationally and medically, its impact on the workplace, and touch on some issues in workers' comp. So I'm going to start off and set the table talking about on a national basis, the state laws that have passed, and also what the federal law has been and policy is changing policy on a federal level. And then Jen's going to pick back up and talk about some of the issues with the employment and drug testing, et cetera. So since 1970, marijuana has been a Schedule I drug. When the Controlled Substance Act was passed by Congress or the CSA, and what the Controlled Substance Act did is it categorized different drugs into different categories, Schedule I being the most dangerous of all drugs. Marijuana is a Schedule I drug. And what Schedule I means is it has no accepted medical use, it has a lack of accepted safety for use under medical supervision, and it has a high potential for abuse. Other drugs in the category are heroin, LSD, ecstasy. Notable is that Schedule II drugs are most of the opiate-based pain medications like Oxycontin, Vicodin, Percocet that we're seeing such an issue with. So just some food for thought. So as a result of the classification under the CSA as a Schedule I drug, there's been very little research done on the drug because it's been so difficult to get access to it. So most of the evidence that we have that suggests that it's helpful for certain medical conditions is anecdotal. And as a result of that, in 1996, California passed Proposition 215, making it the first state in the country legalizing marijuana for medical use. Since that time, we now have 33 states, more than half the states in the country, plus the District of Columbia, who have also legalized marijuana for medical use. Notable is that in the last year, both North Dakota and Oklahoma have passed laws considered liberal in terms of medical use, and those are both very red states, so it's pretty clear that this isn't a partisan issue.
But the amounts and the dosage and the regulations, they change state to state,
right.
Correct?
Each state's law, it can be drastically different. So California, very easy to gain access to in California, while New Jersey historically has been very difficult, although it's loosened up in the last year, and I'll talk more about that in a little bit. We now have 10 states that have legalized marijuana for recreational use, as well as Washington, D.C. If you live in New Jersey or New York, you're probably aware that both governors are now pro-marijuana. They both want recreational marijuana, and it's proving to be a little bit more difficult than they had anticipated. That said, I suspect there will be movement on that in the next year or so. So what we have here is all these states, the patchwork of states' laws that are seemingly in direct conflict with federal law under the CSA. That said, there has been some changing federal policy over the last 10 years, starting under the Obama administration in 2008. When Deputy Attorney General Ogden released a memo followed up by Deputy Attorney General Cole, and the memo went out to all U.S. attorneys around the country, and basically it was a directive telling them, we don't want you getting involved in prosecutions of those engaged in medical marijuana business or users of medical marijuana legally, unless you find evidence of organized crime involvement, or selling to children, or it's going across state lines. So other than that, back off is essentially what the memo said. It didn't have anything to do with recreational, though. It was just medical. But as you can see from the slide, in January of last year, the Attorney General at the time, Jeff Sessions, who is no longer the Attorney General, rescinded that policy and said to all of the U.S. attorneys around the country, the Controlled Substance Act is the law, and if you guys want to pursue prosecutions, have at it. Jeff Sessions is no longer the Attorney General, and I believe the current Attorney General, just sworn in, doesn't have that position, isn't as anti-marijuana as Jeff Sessions was.
Do you find that they're prosecuting?
What is interesting about this is that the news that's coming out, especially out west, is that they're actually not prosecuting, especially in states with recreational marijuana. What they're finding is that the federal government or the DEA is pursuing prosecutions of those in the black market, which is to the delight of those legally selling marijuana. So they're trying to take out the black market, and which opens it up more to the legal market, and therefore they can get the tax revenue. So despite the rescinding of the Cole Memo policy by Attorney General Sessions, and there being a lot of gray area and uncertainty as to what the federal government's position is at this point, because there's been no subsequent memo put out, there is an amendment that's been attached to this federal budget since 2014, initially known as the Rohrabacher-Blumenauer Amendment. I believe now it's referred to as the Farr Amendment, but it's been attached to every federal budget since 2014. It comes up every year, so you have to pay attention to it because there's no certainty it will be attached to the next federal budget. I suspect that there's no fear of it not being attached given the current makeup of Congress right now, but you still have to pay attention every year. When the budget comes up, you have to make sure this amendment's attached. Because what this amendment does is it defunds the Department of Justice's budget to pursue prosecutions of those engaged in the medical marijuana business, not recreational. And so, for all intents and purposes, the federal government or the DOJ doesn't have any funds to pursue these prosecutions. So although it's an illegal banned substance under the CSA, they practically can't pursue the prosecution. And the DOJ actually brought a case back in 2015 against a dispensary out in California. They challenged it. It went to the Ninth Circuit. It was called U.S. versus Marin Alliance. And the Ninth Circuit tossed the case out and told the government, you can't pursue this prosecution because of this budget amendment. So I highly doubt that any other U.S. attorney is going to bring a similar case to be embarrassed like that. So that's the protections in place right now. That said, I'm going to turn it over to Jen, and she's going to take it from here.
Okay. Currently, a lot of employers obviously are facing issues with regard to employers and a safe work environment and the issues of specifically talking today about marijuana. Drugs and alcohol can put not only the employee at risk, but the safety of others and the safety of your customers as well. So many times employers take into account drug testing. A lot of times it's done beforehand. Sometimes it's done during employment. With regard to the New Jersey policy on drug testing, Hennessy versus Coastal Eagle Point Oil held in 1992 that you can do drug testing. An at-will employee, specifically in a safety-sensitive position, can be drug tested and then terminated for positive drug tests. So the key in that case is, and with regard to drug policy testing, is the job that the employee is doing. So is this a safety-sensitive position? And that outweighs the individual rights to privacy. So the factors of random urine testing and whether or not it violates, you have to look at the position that the employee is. Keep in mind sometimes that the testing of these is not just the safety sensitive, but with regard to if they have DOT regulations and whether or not they're allowed to have drug testing, or if this is a policeman, they may have separate regulations. So keep that in mind. OSHA also recently put in a rule that not only does it deal with tracking workplace injuries and illnesses, but the key for this case is that it deals with post-accident drug testing. So OSHA requires that employers with more than 250 employees, sometimes it depends on the industries, it could be less than even 20 employees, but the information not only is submitted, but it deals with the post-accident drug testing. So the question as to whether or not you can do drug test after an accident is specifically discussed with OSHA, and the reason being is they want people to be able to report an accident. They don't want an employee to be concerned about reporting an accident for fear that they're going to get fired because there's a positive drug test. But
they don't want them to be retaliated against.
Exactly. So it's to control possible retaliation. And so what they want to do is they want to make sure that the employees can freely report an accident without fear of retaliation, even if they have or know that they're going to have a positive drug test. What the OSHA rule requires is that it has to comply with the requirements of the state and federal law or regulation, but it also must look at each accident. So specifically look at how the accident happened, and it obviously is on a case-by-case basis, and you need to evaluate whether or not a drug test is something that should be done. Specifically, an example that I always use is you have an employee who's driving a forklift who runs into another employee, both injured. In this instance, the person who was driving the forklift could be drug tested because the accident may have happened due to them being under the influence of whether it be alcohol and or drugs. However, the employee who was hit by the forklift cannot be drug tested because the accident had nothing to do with whether or not he was under the influence or not. So for him, reporting the accident, he shouldn't feel any fear of retaliation with the drug test because it would have had no impact on the situation.
So provided there's no evidence that he was negligent in any way and walked in front when he shouldn't have? Or...
Exactly.
Okay.
So you have to look at each of the situations, each of the cases, and evaluate it. So yes, if he was running in front of the forklift as the forklift was driving normal and it wasn't the forklift operator's fault, then yes, you would be, in that instance, likely drug testing both of them just because one is driving the forklift and ultimately was responsible, but the other individual ran into it. So you have to look, you have to do a lot of the investigation to determine whether or not you can just drug test. There's no across-the-board policy. So
very fact-sensitive to the
exactly. And the recording requirements have to be, that information is also something that's relevant.
You found a picture of me.
A lot of times when an employee, we have the ADA, but in New Jersey we also have the New Jersey LAD, so the New Jersey Law Against Discrimination. With regard to the ADA, their view with regard to drug testing and whether or not someone comes in and there's an issue with regard to whether or not they're under the influence, whether they're currently on medication or taking marijuana in this instance. So you need to evaluate whether or not they're currently engaged in the illegal use of drugs versus whether or not this is someone who had a past drug use but isn't currently using. So an employee is not protected if they're currently engaged in illegal drug use. When an employee or an applicant has used drugs illegally but can be protected, that's someone who has successfully completed a drug program and is not using the drugs, or has the rehabilitation been successfully and isn't using the drugs. If they're participating currently in a program and obviously not still taking the drugs, or if there was an erroneous report with regard to drug use. So someone who actually isn't even on it, but potentially there was a false positive on a drug test, or someone reported them, but they actually weren't found to have been using drugs. So that is someone who would be protected. One of the questions that we see all the time is whether or not you have to provide rehabilitation before discipline. And with regard to, there's no specific requirement that you have to provide rehabilitation. So if someone has a positive drug test or they're found out to have been using drugs and or alcohol in this instance, you don't have to offer rehabilitation. You can. Many times it's something that you want, and a lot of times the participation in an EAP program or something similar to that is considered a reasonable accommodation. So you have to look at the big picture. Are they still using the drugs? What specifically happened? So if it was a positive drug test, but they're no longer using it, what would be a reasonable accommodation? So it's something that you really want to look at. You also obviously need to determine what their position is. So if this is someone that's a police officer or someone who's driving a truck and under the requirements of the DOT, the regulations may prevent you from being able to offer certain types of accommodations. So it's really important to look at what the position is and what they're actually doing. Again, keeping in mind, you may also want to offer a last chance agreement. That's something that may be considered a reasonable accommodation. A reasonable accommodation, you have to evaluate whether or not it's reasonable. That would also be, it depends upon the job. So a reasonable accommodation may be telling someone that they can attend AA and taking off during the day because the AA session is only certain times locally, or that's where they want to go, or that they're attending an EAP program. So there's different types of accommodations. But then again, you also have other individuals. So a nurse who has is using medications improperly can't necessarily be in that position based upon what their job is. So you have to look at whether or not it's a reasonable accommodation. Recovering drug addicts are not entitled to a reasonable accommodation. So if you're still using, that's it. Right. You don't have to offer reasonable accommodation. It's those who are moving on to that next step and are looking to either take a leave of absence to seek treatment, or they want to attend Narcotics Anonymous, or some other, they need to attend an EAP program, which some of the time was during the day. So those are reasonable accommodations, but you have to look at the big picture. You have to look at the position, make sure it's something that you can actually offer. With regard to the New Jersey Law Against Discrimination, this one, the reason that I tell you about it is obviously it applies to smaller businesses. So even with someone as few as one employee, which is different from the ADA, that would be someone who would be protected, and therefore you have to evaluate it similar to you would evaluate an ADA claim, whether or not there is a reasonable accommodation. Is this someone who you can actually offer? Additionally, disability is defined. It's a broader definition, and there's more people that are included. So someone who may have a condition under the ADA may not who may under the New Jersey Law Against Discrimination may not under the ADA. So it's really important to evaluate, if you're in New Jersey, that there's a broader inclusion. Also, just with regard to all these types of situations, the key is whether or not a reasonable accommodation is appropriate or should even be considered. When you have someone, especially in the instance of medical marijuana, in that instance, it's different. New Jersey allows for medical marijuana. In New Jersey, as we had said, it's not legalized recreationally. But it's something to figure out and to be concerned with when it's with regard to a workers' comp. Obviously, under a workers' comp situation, you have an employee who you're directing medical. So you want to make sure that you evaluate and investigate whether the doctor you're sending this patient to can prescribe or does prescribe medical marijuana. So some of the doctors may prescribe it if narcotics are not working. Well, when you have an individual who can't work because of narcotics, you'd have a similar situation with regard to medical marijuana. Right. But with a narcotic, they may be able to work certain hours when they're not taking the narcotics. So you may be able to offer a light duty, whereas the issue with, again, the investigation hasn't been done yet with regard to medical marijuana, with regard to marijuana in general, and therefore it's not like it's going to wear off after 6 hours. You don't know. Right. So it's concerning in those instances. So for workers' comp claims, you really want to use the fact that we control the medical treatment to evaluate the location and the doctor that they're going to see. Right. If it's not a workers' comp claim, you want to make sure that obviously they're being cleared by a doctor. If a doctor is prescribing medical marijuana, that's something that I'm sure that they would be disclosing, especially depending upon the job description. There's certain documentation that they would have to provide to return to work. So it's something to keep in mind with whether or not it's a work accident or any type of injury that they're coming back from. But you need to evaluate the reasonable accommodation, whether or not it's something that allowing them to take medical marijuana is appropriate compared to, is that even something that can be a reasonable accommodation? The problem is that federally, it's not something that is permitted. But the state's view and the fact that the states are allowing it, it puts employers in a predicament, and I know you're going to talk a little bit more about the predicament with regard to the...
Do you have to employ or offer a job, or can you deny employment based on it? And just one quick thing on the workers' comp, and one of the main issues that keeps coming up is the fact that you can't test for intoxication with regard to marijuana, which is a real stumbling block. It's really a case of where the social policy is getting out ahead of the science. So, you know, you have an employee who is involved in an accident and you test them for drugs and marijuana comes up and the employee says, but I wasn't using while at work that day. I smoked marijuana 2 weeks prior, because it stays in your system for, they say, at least up to 2 weeks. So the issue is you're not sure if they were intoxicated on the job or not. So you really have to do your due diligence post-accident with respect to a marijuana suspicion that somebody's using marijuana, if they don't tell you directly, as to whether or not they were intoxicated. That's really a big issue with regard to marijuana.
And while it's considered medical marijuana is permitted, and especially if someone is saying, well, you know, I am allowed to use it, I was prescribed it, and I haven't used it, I didn't use it while working, I used it last night, you have the issue of whether or not that's something that's permissible. And the problem is that federally it's still not permitted. So employers face that struggle, and it's something that they're concerned with about whether or not they're allowed to terminate someone based upon that. So again, you have to evaluate it based upon the position, like we talked about.
And that's a good segue into what I'm going to talk about, because I'm going to specifically talk about cases that actually address that issue and how they've come out over the last few years. And before I get to that, I just wanted to touch quickly on New Jersey's medical marijuana law, because it was, I said earlier in the program, it was expanded in March of 2018 by Governor Murphy, and notable additions to the legislation were chronic pain, and cutting in half of the cost, really lowering the barrier to gain access by residents of New Jersey. So from 2010 till 2018, I think you had about maybe 15,000 enrollees in the program in a state of, 8 million, something. And since he cut the cost in half and added chronic pain, migraines, anxiety, and Tourette syndrome, it's more than doubled in a matter of 8 months, which means for us, you're going to be seeing more issues arise as a result of it.
And the doctors, the types of doctors that are qualified to prescribe, keep in mind, it's not just a pain management doctor. These are based upon the types of injuries that are now covered under the prescriptions. You have, it could be a general doctor, it could be a psychiatrist, it could be a pain management doctor, it could be a surgeon. There is a list that you can go and check and confirm whether or not a doctor is permitted to prescribe medical marijuana. So again, if you're addressing it in workers' comp, you want to keep that in mind and make sure you check to see if that doctor's on that list, right, if you're concerned about that.
And that's another thing. They took that list offline, which it had used to have been, which prevented a lot of doctors from being interested in being put on the list because they felt there was a stigma attached to it. So there was very few doctors, relatively speaking, in the state that wanted to be known as marijuana doctors. Now they've taken that list away from being online, so they're not out there to the general public, but you can find out what doctors are going to be able to prescribe you marijuana.
Right.
Notable about the statute as well for employment purposes is this section here, 2461(8)(a). It states that the provision of this act shall not be construed to permit a person to operate, navigate, or be in actual physical control of any vehicle, aircraft, railroad train, heavy equipment, vessel while under the influence of marijuana. So these are all safety-sensitive positions, right?
But again, it has that under the influence.
Right.
And since that's still
it's
not...
a little gray area.
Exactly.
Right. So that leaves room for interpretation, for court cases to go forward, and judges to make rulings on this issue. Another notable section is 2461(14), and it states, nothing in this act shall be construed to require any employer to accommodate medical use of marijuana in any workplace. That's really a blanket for the employer to take action against an employee. It really says we're not providing any protections for employees here. Now, there have been cases brought and under the New Jersey LAD, and these cases have gone in favor of the employer, but I'll get into that more. There's a current proposed change to this section of the statute, and in this change, it essentially says if you are a registered cardholder in New Jersey, an employer can't take action against you simply for that. But again, the employer does not have to accommodate on-site use or if an employee is carrying. And it's really kind of gray as to when, if there's a positive test, were they intoxicated at work? So it's still not a really good cover for an employee using medical marijuana. Pennsylvania also has, and what we're talking about here is Pennsylvania, this is an example of an anti-discrimination provision in a medical marijuana act. And there's about 10 or so states that have this included. New Jersey does not, as I just noted. They may have it, some version of it, which I just alluded to or talked about. But Pennsylvania is here. It's no employer may discharge, threaten, refuse to hire, or otherwise discriminate, retaliate against an employee regarding an employee's compensation terms, conditions, location, solely on the basis of their individual certification to use marijuana. So that's a version of an anti-discrimination provision in a medical marijuana statute.
So when addressing the reasonable accommodation, and now for New Jersey, obviously it says currently that's not a reasonable accommodation, but depending upon where the employee works, if they're in another state, or if they work in more than one state, they have to make sure that whether reasonable accommodation is something that they can't terminate for. So if you have an employee that works in both Pennsylvania, New Jersey, or New York, you have to really look at each of the states. And
that's an interesting question.
So,
an issue that will probably arise, and we'll see it arise. Yeah.
Exactly. So keeping in mind that this is continually changing.
Yeah, and you have to be on your game with this because it is changing. So Delaware has a similar anti-discrimination provision in its statute. But as a general rule, employers in all 50 states and the District of Columbia can regulate an employee's use of marijuana by certainly prohibiting marijuana use or possession at work. It's pretty clear that even all the anti-discrimination provisions in the states that have them don't permit use at work or someone possessing it at work. It's still a Schedule I banned substance under federal law. Again, there's gray area as to if you're intoxicated or not, and that's going to be arguable and fact sensitive. Prohibiting employees from reporting to work impaired or under the influence as well. Now, some companies have to have a zero tolerance policy because they get federal funding under the Drug-Free Workplace Act, or they're governed by the DOT. Private employers are, a lot of them adopt zero tolerance policies as well. Interesting, the news is that out west where a lot of states have legalized marijuana for recreational use, a lot of employers have made the decision to take marijuana off their initial drug screening because so many citizens are, using marijuana as if they were drinking alcohol, that their pool of employees to choose from has dwindled drastically if they're going to test for marijuana. So a lot of large employers have taken it off their pre-employment drug screening.
Otherwise, they're not going to have qualified employees that are working and.
Right. So that's one way they're addressing it. Yeah. Now, all of this said, you need to know, as I said, if your state has an anti-discrimination provision. Can an employee be fired using medical marijuana legally? Well, it depends on the state. If intoxicated or using it at work, generally yes. Then look, if not, then look to see if your state has an anti-discrimination provision. And there is a list of most of them right there. And after that, if it does have or it doesn't have, you want to look and see if there's been any decisions on the topic. And notable is decisions for the employer early on when this issue was coming up. The states out west who had passed their laws before anybody else, like California and Colorado, had to address this issue. And interestingly enough, in the most liberal states in the country, those courts ruled in favor of the employer. So here's a quote from Ross versus Ranging Wire. It's a 2008 California Supreme Court case, and they held the purpose of the medical marijuana law was merely to protect a patient from criminal prosecution. It didn't provide them with any affirmative rights, essentially. Colorado, a big case came up where a quadriplegic Dish Network employee at a call center, clearly not a safety-sensitive position, was working. They drug tested him. He had a legal medical marijuana card under Colorado law. He brought his claim under the Colorado Lawful Off-Duties Activity Statute, which a lot of states have because they don't have an anti-discrimination provision in Colorado. And essentially what a Lawful Off-Duties Activity Statute says is an employer can't take action against an employee for doing something in their private life that's legal. So smoking marijuana for medical use, if you have a certified card in Colorado, is legal. So he brought his claim under that. And the Colorado Supreme Court still ruled in favor of the Dish Network, saying that lawful in the statute doesn't define whether or not it refers to federally, and it's federally illegal. So,
well, and keep in mind, so for New Jersey specifically, it would be applied differently because obviously that type of individual, because they're not in a safety sensitive position, could never have been drug tested at that point. So while New Jersey may have come out in a same finding, that employee would never have been drug tested, or it wouldn't even have gotten to the point where the court could have found in favor of the employer because of the fact that they were in violation of, he should never even have been drug tested.
Right.
So
Good point.
You have to look at the big picture. It's not just it's a lot of different factors.
Right. And to New Jersey, recent decision in 2018, we've had two of them in 2018, Cotto versus Arda Glass. It was a federal district court ruled that the employer does not have to waive its requirement for mandatory drug testing for a worker using medical marijuana under the NJ-LAD. The employee brought the claim under NJ-LAD coupled with CUMA, the Compassionate Use Act of New Jersey, which doesn't have an anti-discrimination provision in it. And the federal judge said that, court determined that nothing in the New Jersey Law Against Discrimination or CUMA will require an employer to accommodate an employee's use of a federally illegal substance by waiving its requirement to complete a drug test. So the court did touch on the fact that it's federally illegal, and that weighed into the opinion a bit. Another case came out as well, Wild versus Carriage Funeral Holdings. This case, they again ruled in favor of the funeral home. It was a funeral director who was involved in a motor vehicle accident at work. Accident was not his fault. He had cancer and was using marijuana legally under the state law, had a card. He testified and, he was not under the influence while at work, but the court still ruled in favor of the employer. And I think the fact that part of his job involved operating a vehicle probably weighed into that opinion.
Correct.
Delaware, a case came out similar. Delaware has the anti-discrimination provision. Delaware's court recently found, it gives an implied right of action by the employee under the Medical Marijuana Act, the actual anti-discrimination in the Delaware statute. And also notable about the Delaware decision is they addressed the potential conflict with federal law, and they said there is no conflict. Because federal law, essentially, it's not, the employer isn't required to do anything illegal. It's the employee who potentially is doing something illegal under federal law.
Now, that would be different for workers' comp. We have some states that employers control medical treatment and others where the employee controls it. If it's the employee controlling their own medical treatment, then obviously they can see who they want, and if they're prescribed medical marijuana, that's one type of situation. But for workers' comp, where you control the medical treatment, there is the concern, rightfully so, with regard to the employer paying for medication that's in violation with federal regulations. And
marijuana.
So, exactly. So because medical marijuana is permitted in New Jersey, but it's not federally permitted, there's a problem for employers who are being asked to pay for it. And since in New Jersey you have the right to control it, it's something to keep in mind. Other states such as Pennsylvania, where we don't have the right to control or direct medical treatment, it's a little bit more sensitive and a little bit more complicated. So right. keep that in mind.
And when faced with that issue, if you are, with regard to paying for it in the workers' comp arena, on behalf of an employee, most all of the case law out there from around the country, where a judge has ordered a carrier to pay, and they did in New Jersey, they never order the carrier to pay directly. They always order the carrier to reimburse for the cost, thinking that maybe that provides a bit of insulation from a federal prosecution, which I doubt would happen, but you never know. And whether or not it provides insulation, I doubt it. But there's been some decisions for the employee in the employment context over the last few years. And interestingly enough, it's from the New England states. All of these decisions following, and Delaware, pretty much the case recently in Delaware followed suit of Rhode Island, Massachusetts, Connecticut, wherein they found in favor of the employee when the employee was denied employment or terminated. And again, those two cases, Rhode Island and Massachusetts, the courts addressed the potential federal conflict, didn't think there was one, and ordered the ruled against the employer in those cases.
And were these, if you know, safety-sensitive positions?
One of them, no. This case here, interestingly enough, was a federal district court, again in Connecticut, wherein the Federal Drug-Free Workplace Act governed, and the court actually addressed it. And obviously, as I said earlier, if you're governed by a Federal Drug-Free Workplace Act or the DOT, you're probably safe. But in this case, they were governed by it, and the court regardless said the Drug-Free Workplace Act does not require drug testing and does not regulate employees who uses illegal drugs outside of work while off duty, and therefore they found a way around that. Really interesting in terms of finding their way into it.
And that was a pre-employment drug test?
Yeah, I believe so. And also interesting and notable about this is all of these decisions, the Connecticut, Rhode Island, and Massachusetts decisions, they came down before Attorney General Sessions rescinded the coal era policy. Whether these decisions would come down the same after the rescission, you don't know, but it's certainly shown to have impacted. There was a Maine Supreme Court decision in the workers' comp arena wherein the Maine Supreme Court overturned the appellate division decision saying that the carrier had to pay for the cost of marijuana, and the Maine Supreme Court's reasoning actually cited to the coal memo policies being rescinded and said requiring a carrier to pay for the cost of marijuana would be requiring them to aid and abet in the commission of a crime. So these federal policy decisions are clearly weighing on judges' opinions. So that's something to be aware of. So quickly, just some takeaways here. Delaware joins a growing number of states that I've just talked about rejecting the federal preemption arguments and have permitted discrimination claims to proceed based on the state's medical marijuana anti-discrimination provisions. You really need to know your state's laws and consult with counsel on these issues when crafting a policy, a drug policy.
Yeah, drug policies or your accommodations, when evaluating it, something you really just need to look at all factors. You can't just unilaterally agree to drug testing across the board. All the different states, there's too much. It's too complicated. You really need to evaluate and make sure that your employee handbooks are up to date and they create exceptions for you. So that's something to take away. And we just wanted to thank you for attending our webinar, Workers' Comp ADA Medical Marijuana. You can learn more about this program and other Weber Gallagher events by visiting our website at wglaw.com. Thank you very much. And again, if you have any questions, please send an email to questions@wglaw.com, and that can include a request for the PowerPoint presentation as well. Thank you.
Great. Thank you.